Good morning, Mr. Crouch.
Good morning, Your Honor. May it please the Court. Andrew Crouch on behalf of Richard Kulesa, who appeals from convictions out of the Middlesex County Superior Court. I'd like to start today at the end of Mr. Kulesa's case with respect to the subsequent offender portion of his proceedings, in which just moments after having been convicted of multiple convictions in the court, the trial judge makes the inquiry to him, do you wish to have counsel appointed for the subsequent offender portion? And sort of reeling from that conviction, Mr. Kulesa initially answers, no, I don't want that. But then within just a few quick seconds, essentially the next line in the transcript, he changes his mind completely, says, basically says, I want an attorney, bring the attorney in so I can talk to him.
Is your argument on that point statutorily based, that is Section 11A, if I've got the right section?
I think
that the language at the end of that section,
yeah, I think
about all the rights that pertain to
there is both, I think, a statutory argument here and a constitutional argument to be made. The statutory argument in Section 11A, I think that the language is pretty clear that the individual is entitled to all of the rights incumbent upon an individual who is facing criminal proceedings. Obviously, the longstanding rights, both in the SJC's rules and the criminal rules, and especially the Sixth Amendment and Article 12, provide a rights counsel is attendant to those trial rights. So I think Section 11A statutorily provides that. I think more, beyond that, both Article 12 and the Sixth Amendment also constitutionally provide the rights counsel at that point.
But with respect to that, and maybe I'm just not quite getting this, but I take it that the Pelletier, if I've got the name right, case suggests that if you had a plea to both and you gave notice, that the first plea could
it influences its second event. I think what Pelletier talks about here, and I think that, and this is the crucial point, that the judge here is not making a determination based upon some sort of an abuse of discretion standard that there's delay. She is making the determination when she comes back into court after both her and the ADA agree that the defendant has indeed requested counsel, that her hands are tied by Pelletier. She suggests that case binds her, and I think that it does not. I think what Pelletier suggests is that if there is, and I think it is a separate, I think the offer of a plea there is to be considered separate from the right to counsel. But what Pelletier suggests is an individual who offers that plea initially, if there is going to be a plea in a later proceeding, that those proceedings can then be somewhat circumscribed. We can save some time by not having to repeat that which we may have just already repeated a few minutes earlier or within a time that the defendant is going to be familiar with that. Here, it's a different situation entirely with respect to the rights of counsel.
I guess I was really sort of going to the constitutional issue, and you're just saying that Pelletier really doesn't get to this issue. Is that what you're saying?
I don't think that it does. I think that the constitutional issue is much broader, much more involved. I think specifically it can be looked at in one of two ways. The amicus brief talks about, from CPCS, does indeed talk about situation where counsel, because Mr. Kulesa, after he is convicted of the initial charges in the Middlesex court, is then later arraigned. So it is at that point when she's asking him for counsel, he's not even been arraigned on the particular charge, the subsequent offense portion of the charges. So there is the argument that the amicus brief talks about, that is actually when, with respect to Lavallee, that is indeed the time when counsel attaches. I think there's also the other argument to be made that is also touched upon in both the brief and in the amicus with regards to a reassertion of the right to counsel, both under the Sixth Amendment and Article 12. It's important to note that in all of the amicus briefs that we've seen here so far, not one federal court of appeal, nor has the Supreme Court, ever made a determination that once somebody waives the initial right to counsel, that right can never be reasserted again, that is somehow, I think the amicus, I think Justice Marshall puts it well in his dissent from a certiorari denial in the CPCS amicus brief. But that is not a situation where that right just suddenly disappears.
Well, as a practical matter, we really don't do it that way. In fact, we often have standby counsel, and we often, I think, hope, although a defendant has a constitutional right not to have counsel, that we hope that the defendant somewhere in the middle of the trial perhaps will say, actually, now I would like to have my lawyer.
That
And
is
even when we don't have standby counsel, we have sometimes allowed defendants to interrupt a trial and to get their lawyer.
That is indeed true, and that happens throughout the case. Well, and there's, as you know, as your Chief Justice notes, there's a good reason for that. We understand that while there is this right to represent oneself, that it is undertaken with great peril and is not recommended whatsoever. And courts usually do a very good job of explaining that to defendants as they go through the process. I think the important point in looking at a standard of review here is that the typical standard of review for a denial of counsel is one about abuse of discretion. But the standards that we've looked at through all of the courts of appeal that are cited in the amicus briefs and in the cases of this Commonwealth and of this court solely relate to whether or not a judge has abused the discretion in denying counsel because of a dilatory action of the defendant, or which usually manifests in an attempt to delay the proceedings. I think what's important here is that there is a complete absence of any such evidence in this case. Mr. Kulesa could not be more clear that he wishes to get these proceedings done that very day. He tells the judge, the judge asks, can you get this done this afternoon? He says, yes, I can get this done this afternoon. Bring in your counsel. Let me talk to him. He is not attempting to delay whatsoever. So I think that this is not an abuse of discretion sort of situation. This is a straight denial of a right to counsel, be it a reassertion of a previous right or an invocation of a new right that is incumbent with the later having been arraigned on the subsequent offender portion and having the right to counsel under, say, Lavallee come in at that time.
I just have a question about something you say on page 19 of your brief. You say, while Section 11A partially proscribes the defendant's right in a subsequent offender trial by limiting him to the jury used in his underlying matter. But as I read Section 11A... That would be a misstatement, Your Honor. Yeah, because you can have either the same jury or a new jury.
Correct. That is indeed that would be a misstatement. That is indeed...
Right.
Section 11A, and I think it's important to note in this situation, Mr. Kulesa, after speaking with his attorney, would have had the opportunity to either, and I know the Commonwealth addresses this in terms of being concerned that there has been no attorney present throughout the entire proceedings, and then in this very unusual set of circumstances, I would submit, is going to somehow delay the proceedings. Here, the Commonwealth or the district attorney at the trial court level suggests is not in a rush. Mr. Kulesa is being held on bail. They say they could continue it to the next morning. But as Justice Cowan notes, Section 11A does indeed empower the trial judge with the discretion to either continue with that same jury or to impanel a new jury. And I would suggest that the trial judges are certainly within their understanding to take a look in these very unusual circumstances to suggest that maybe if indeed a counsel comes in, and we don't actually know what happens because no counsel is available in the room at the time that the invocation of counsel starts, and then the judge suggests that her hands are indeed tied by Pelletier.
Mr. Crouch, I'll ask Ms. Pogue, but the Commonwealth seems to be taking the position that there was not, in fact, an invocation of the right to counsel.
I believe that is indeed their position. I think that is not supported by the record. I think it's not supported by both the judge and the district attorney's own responses, in which they say, if he's asked for an attorney, we have to give him an attorney. They both agree with that. Neither of them is arguing, or the district attorney is not arguing at the trial court level, that the invocation is somehow unclear. And I know there's a citation to a case where there's an individual in a police precinct room saying, well, maybe I should talk to an attorney. Here, I think it is more clear. He is making statements, that go get one so I can come back and talk to him about it, please. He then reiterates, bring your counsel in, let him talk to him. I think that it's a clear invocation of a right to counsel, especially as the trial judge herself then takes a break, goes out, and ostensibly is looking for an attorney because there was none in the room at that moment, but instead is actually looking at Pelletier and is feeling that her hands are indeed tied by that particular decision.
Now, why is this different from the invocation during the course of trial? Pragmatically, it means, in most cases, probably here, that you have to choose a new jury because there's no counsel available. When you find counsel has to do his or her due diligence to prepare. And pragmatically, you're not going to have a jury sit there for an indefinite period of time in order to complete the trial. Isn't this effectively meaning that that a pro se defendant has the ability to ensure himself a newly chosen jury by invoking a right to counsel?
I think that is a rightful concern, but I think it is within the discretion of a trial judge under particular circumstances of any particular case, depending upon the number of attorneys, the timing of the request for counsel, the circumstances of the request for counsel. In these proceedings and subsequent offender proceedings, as the court is well aware, the evidence that is presented is typically very limited, and this is a classic sort of case. We only have 10 or 11 pages of a trial. The only person who actually testifies is actually in the building itself, so this is not a situation where we have substantial delay with dozens of witnesses or even 3 or 4 witnesses who have to be bothered to come back. Here, there isn't that sort of delay in the administration of justice. There is some concern, but I think it can be held to the individual circumstances of individual cases to the trial judges to make a determination whether, under the circumstances, there is a dilatory hint to the invocation of counsel, or whereas in this case, Mr. Kulesa is clearly not understanding the proceedings. He doesn't understand the nature of the charges against him. He at one point thinks he has the burden of proof. He is entirely confused by it. And while he did have prior counsel that he asked to have withdrawn, he proceeds through the entire trial.
3 counsel. When the 3 lawyers
He
fired?
did indeed have 3 lawyers, but they were terminated long before we get to trial. He goes through the entire several days of trial representing himself. There's no hint of delay. There's no hint in trying to upset the administration of justice. So I think under the circumstances of this case, he is not looking to cause that delay. He's not looking to get himself a new jury. In fact, from what happens, he indeed is not even looking for that jury. He looks to go for the judge. But we don't know, because there isn't an attorney available or isn't an attorney appointed, to actually know what the decision would have been made if he had actually had the benefit of counsel.
Yeah, so if attorney is appointed, comes in and says, okay, I've talked to him, I can't try this case today.
And there are, as the CPCS's brief talks about, in a lot of other states, they do have a delay in that process. And maybe it is a couple days. As I said, these are relatively simple proceedings. While it would indeed take an attorney potentially some time to move this forward, and it's a question of whether or not Mr. Kulesa, even after speaking with counsel, would have wanted him in a standby capacity, where it would have required perhaps less work, or in a full capacity. We just don't know.
What's the difference in the sentence?
In the sentence here, he received a period of 10 years probation. The statement, the sentence here, this was the one that really got him. I mean, the subsequent offense, he ended up with a sentence of 7 to 9 years on the subsequent offender portion of this charge. So it was indeed this, while the underlying convictions are important, it is indeed this subsequent offense charge that leads him to be
incarcerated. What's the harm anyway if you have to wait a day or 2 or a week for the next trial? I mean, the defendant is probably going to be held once he's convicted on the first offense, and he's awaiting a subsequent offense. I would imagine most judges would hold him. So what is the big difference if you have to wait a few days?
I don't think there would be one. And in this case, as Mr. Kulesa makes clear during the trial, unfortunately, he isn't being held on a $50,000 cash bail. He, at that point, even if the case is continued, he's not likely going anywhere, but he could indeed be held based upon those other convictions for this enhancement proceeding. So I don't think there is any sort of a danger in that respect.
I have a question for you on the duplicative part of your argument. How does Commonwealth versus Vic, which we decided very recently, affect your case?
Unfortunately, off the top of my head, I don't, not familiar with that particular
Commonwealth
part.
versus Vic is a case that talks about whether, and we were hoping, I think, to definitively answer whether convictions are duplicative. Perhaps you want to send in a 16-year-old letter.
I'd be more than happy to do that.
It was decided July 30th, 2009.
Yes, I'll be more than happy to do that.
But even, well, if you're looking for elements, I mean, there really are there are different elements in both of these crimes.
This is an argument that is put forward by the defendant at the beginning of trial and continuing to hear. There is certain language. I think the main arguments are best put forward in the brief, but I'm happy to answer any additional questions with respect to that issue. Thank you very much.
Thank you, Mr. Crouch. Ms. Pogue. Good morning again.
Good morning again, Your Honors. May it please the Court, Ann Pogue, Assistant District Attorney from Middlesex, on behalf of the Commonwealth. Your Honors, there was no violation of the defendant's right to counsel First and foremostly because the defendant did not request counsel. After the jury verdicts
Didn't the judge and the colloquy before the judge left the bench understand that there'd been an invocation of right to counsel?
I would not agree that that's in the record, Your Honor. The judge on page 101 to 102 of the transcript from January 31st, the judge asks the defendant if he wants counsel. The defendant clearly and unequivocally says, no, because I know the law. Why should I have counsel? All they do is sit there and tell you, oh, you did this or oh, you did that. And he does say, let me have counsel so they can talk to him being the prosecutor, in an attempt to negotiate a plea. But that was also the last attorney that had been appointed to represent the defendant was appointed as standby counsel to attempt to negotiate a plea with the district attorney's office. When that failed, the day before trial at the final pretrial conference, the defendant dismissed that attorney, chose to represent himself, did not even want that attorney to represent him in a standby capacity. And then after saying, no, I don't want an attorney, although he did say, well, maybe I'll talk to one, he asks what lawyer it would be. The judge says, there's no one in the courtroom right now. But the defendant says, who's the lawyer? Where's the lawyer? Go get one so I can come back and talk to him about it. And then he says, if I have counsel appointed, do we have to drag this proceeding out? And at that point, he doesn't say anything else about whether he wants a lawyer or not. And I would suggest to this court that that is not an invocation of his right to counsel, particularly where Justice Haggerty was in the position where she was aware of the circumstances where this defendant had already dismissed three attorneys.
She interpreted it to be, yeah.
I'm
If
sorry?
he wishes, I think we have to accept that.
Didn't she interpret it to be a request for counsel?
She doesn't state, I suppose that's one possible inference to be drawn.
But that's what the assistant district attorney says. Says, if he wishes, I think we have to accept that. And the court said, I do too.
And then she comes back and says, I spoke too soon. Pelletier says you don't get it. But I mean, it's clear she understood him to have invoked a right to counsel.
Well, assuming that was her finding, I would also dispute defense counsel's suggestion that she felt that her hands were tied by Pelletier. She simply states that during the break she read Pelletier and concluded that based on the language in Pelletier that this was a subsequent offense, not a separate proceeding, and he'd already waived his right to counsel. She does not say that she may not appoint a lawyer to represent him.
No, but she she may be right or wrong about that, but she clearly understood that he was asking for a lawyer. And then she said, you're not entitled to one because you've already waived. But I don't think there can be any doubt on this record that she understood that he was asking for one.
Well, in any event, again, I would suggest that even assuming
just to go back to, I don't know whether your hands are tied, but she says, the assistant district attorney, as I understand it, says if he wishes, the defendant wishes an attorney, we have to accept that. And she says, and you're only talking here about the subsequent defender portion, the judge says, oh, I do too. Then she goes out and comes back and says, no, I've read Pelletier, and you've waived it. I mean, that's about as close to saying your hands are tied.
Well,
she's already said once, if you want counsel, I'm going to give you counsel. And then she goes to find counsel, and then she comes back and says, oops, I've read an opinion, and it's waived.
Yes, but I would disagree that suggests that she felt she could not appoint a lawyer. I would suggest that when she read Pelletier, she concluded it was in her discretion.
In any event, she didn't appoint one, and that's the issue, she should have.
Yes, she did not appoint a lawyer, and there was no error in that.
Because?
Because, as is suggested in the amicus brief from Norfolk County, the Commonwealth's position is that was an issue that was in her discretion at that point. And based on all the circumstances that she knew, which was the defendant's prior dismissal of other attorneys, what would surely be delay in the proceedings, the fact that there did not appear to be a lawyer present that day, the defense that he proposed to advance, that
Ms. Polk, let me ask you this, and I take it as a representation to the court. Mr. Crouch says if we go back and look at all of the cases where we've used an abuse of discretion standard, those have been cases where there is an indication on the record or a specific finding by the judge that the defendant is invoking right to counsel in order to get a new jury, as Justice Gantz suggests, delay, all of those kinds of things. Would you agree or disagree with that? Are there cases where there's been no attempt to delay, no attempt to impede the normal orderly process of a trial, but a defendant concludes that while he might have thought he knew all the law, maybe he doesn't?
I am not familiar with cases in this jurisdiction, but this court's ruling in Johnson, it was in fact the judge who suggested to the defendant in Johnson that perhaps he might want to reconsider his decision to go to trial pro se on the day of trial. And when that defendant did accept the judge's invitation and asked for a lawyer, the judge then changed his or her mind and denied the defendant's request for a continuance, forced him to proceed pro se. This court in Johnson held that there was no error in that ruling. And again, for that reason, because it was in Justice Haggerty's discretion and she appropriately exercised her discretion here, that's why there was no error. There was no violation.
But if she said, so you're saying that it was a discretionary determination by her that there was a waiver? That was discretionary?
No, he had already, no, that's, I apologize, that's not my
Because that's what
argument.
she said. She said you've waived it.
Yes, he had already waived counsel, and my understanding is that the defendant is not contesting that he had already waived counsel.
No, I know he did to begin with, but she comes back and she says you're not entitled to a lawyer. I've read Pelletier. You've waived it.
Yes.
So where's the exercise of discretion?
In her decision not to appoint a lawyer.
But she's saying it's waived. Is that what you're saying? That was a discretionary determination on her part?
My position would be that she would have had the discretion to appoint a lawyer. She would have had the discretion to allow him to rescind his waiver and appoint a lawyer to represent him had she chosen to do so. She chose not to do so.
Well, I thought you were saying something differently, that putting waiver aside, she was exercising her discretion not to do so in the circumstances of this case. But because I don't see how you could say that.
I'm sorry, I'm not sure if I understand your question.
You are saying that she had the discretion, in spite of the waiver, to appoint counsel.
Yes. And
you're saying she chose not to.
She chose not to do so.
Separate exercise of discretion, you're saying.
Yes. That would be our position. That the defendant had already waived his right to counsel. He does not dispute that he waived his right to counsel.
But
she was aware.
She knew that he'd waived his right to counsel before.
Yes.
Right?
Yes.
And so when he invokes his right to counsel, it's assuming that it's an invocation, she's saying, well, I've got to give him one now.
My read of the transcript, Your Honor, is that at the time he evidently requested an attorney, the judge felt that she was required to appoint one for him. And then she took a recess, she read Pelletier, and she came to the conclusion she was not required to appoint one for him. That at that point, the trial had already been going on for 4 days, there were no lawyers available. Appointing a lawyer to represent this defendant, who had already released 3 defense attorneys previously, would cause a delay in the proceedings.
But there's nothing in the transcript that says anything about delay. Is there?
No, there's not. But I think that this court can infer that because there was no attorney present, that to appoint a lawyer to represent this defendant would have required some measure of delay. Even if it was only a few days, there would have been, by necessity, some amount of delay.
A finding of guilty of a subsequent offense is fairly serious, isn't it?
Yes, it is. Yes, and although subsequent offender proceedings are, in one sense, simple because they tend to involve fewer witnesses and fewer exhibits than a full-blown trial, it's also a more technical, certainly, exercise than perhaps simply a normal questioning of witnesses. But again, our position is that it was within the judge's discretion, and she appropriately exercised her discretion.
So your position essentially is that this is no different from him asking for counsel during the course of trial or,
After he waived it,
or prior to a
Yes.
routine sentencing?
Yes, that is our position. Our position is this subsequent offender charge is not a separate proceeding. It is a sentencing phase or enhancement that is merely another chapter in the ongoing proceedings for this criminal offense. And because of that,
If we were to agree with you but were to disagree with you as to what your interpretation of what was happening in this judge's mind, namely it was in her discretion, but she felt bound by, hands tied by, or something else, Pelletier, what is the relief?
well, Your Honor, in the past when this court has found that there was some error with regard to the subsequent offender proceedings, this court has affirmed the underlying convictions and remanded the matter for further proceedings on the subsequent offense portion only. But again, I would argue that this was not a separate proceeding. General Laws Chapter 278, Section 11A clearly assumes that they are one proceeding, that it's not a separate charge. This court stated in Pelletier that the subsequent offense portion relates to sentencing. It is not a separate charge. It is not a separate criminal offense.
What about the arraignment?
I would suggest that, although it's colloquially referred to as an arraignment, that where the purpose of an arraignment is to inform the defendant of the charges against him, that has already been accomplished at the time that the defendant is first arraigned in superior
I
court.
mean, you say it's colloquially called. It's a formal arraignment that occurs, isn't it? I mean, the defendant is placed at the bar, and the clerk reads it and goes forward like that, like any other arraignment, I believe.
Well, Your Honor, I am not sure that that is what happened in this case. I don't believe that the indictment was read to him at that point.
Well,
In
often
fact,
it's waived. The reading of the indictment is waived, but in terms of the, was it a
yes,
an arraignment
Your Honor is correct.
wannabe?
He did waive and then he entered a plea.
Do we know, or can you tell us, whether at the original arraignment, when he first appeared in court on the underlying charge, the indictment that was read to him also contained the subsequent offender provision?
My understanding is that the indictments, the actual papers are passed together. However, Section 11A explicitly prohibits the reading aloud of that portion, of the subsequent offender portion. Okay. But I would suggest to this court that because the statute contemplates being able to continue a subsequent offender proceeding with the same jury immediately after the underlying trial is over, the defendant must have already had notice that this charge is pending, must have already been eligible to receive discovery. And the fact that the Commonwealth is permitted to move for pretrial detention on the basis of certain subsequent offense charges strongly suggests that, in fact, the defendant, in terms of an arraignment being made aware of the charges against him, that has already occurred.
I'm not, clearly
But you're
his
saying it's
lawyer
11,
was-
go ahead, excuse me.
No, I'm just saying as a formal matter, there was a separate arraignment, and then you have a statute that talks about if he pleads not guilty, he shall be entitled to a trial by jury on the issue of conviction subject to all the provisions of law governing criminal trials. There's a provision that maybe it could be a separate jury. I mean, it really does, I agree with you, it's not a, it is a subsequent offense, it is a sentence enhancement, but Section 11A really does seem to separate these out and may, with that language, suggest that there is a separate right to counsel for that proceeding.
Well, certainly the Commonwealth's position is that because it is a sentencing enhancement, like any sentencing hearing, the right to counsel is the same as with the underlying charge, that there is not a separate and independent right to counsel.
What do you think the constitutional protections are that are encompassed within 11A?
Well, 11A clearly requires that a defendant be afforded all constitutional protections, and I'm certainly not suggesting that there is no right to counsel. What I'm suggesting is that he had already waived his right to counsel, and that waiver applied to this proceeding as well.
If he had entered into plea negotiations for a disposition on the entire indictment, is the defendant at the plea, arraigned on the subsequent indictment? Is it the subsequent offender element? Does that ever happen?
I don't know the answer to that, Your Honor.
Yeah.
Sorry.
I think that does happen.
Thank you.
Thank you, Ms. Pogue.
Unless there are any other questions, I'll rest on the brief.
We'll take a short break.